Hello and welcome to my presentation. My topic is Nazi Germany and it's on genocide in World War II. And my title is An Interpretation of Genocide and the Impact on International Criminal Law. Okay, now let's just get into it. So, the issues for international justice. So the issues involve around genocide is that genocide incorporates several different crimes, and the aspect of genocide is that it involves a mass murdering, mass torture, extermination of certain ethnic groups, and also rape is involved in that definition as well. Which these were among the crimes committed post World War II. So genocide was considered a rational strategy according to Nazi psychological and criminological theorists. So at the time, biocriminology was at its peak, and they adopted theories that criminalized ethnic groups through racial hygiene and racial cleansing theories, which the Nazi Party adopted in line with policy to implement their wartime atrocities with rationale. So this led to the interpretation of genocide at the time was very underdeveloped and under-researched by criminologists, which the umbrella of genocide gives in a variety of crimes, which is under that umbrella, which makes it harder for criminologists to determine what is genocide and who commits it. So post-World War II, defining genocide was also an ambiguous task for criminologists, as it relied upon only statutory interpretation. For instance, the Nuremberg trials. Since the inception of the Convention on the Prevention and Punishment of Crime, 1948, policy has been frozen in time. This is one of the issues for modern frameworks, and we'll get in that to a bit later about the problems with these responses. So the Nuremberg trials also posed a tremendous issue regarding international and national jurisdictions, which the main principle of research was the nullum crimen principle, which is the principle of legality, which criminologists have spent a lot of time on and a lot of time developing an understanding of that aspect within the Nuremberg trials and how it was such a ambiguous task for international courts to develop a clear, concise, defining principle of genocide to punish the men on trial. Current responses to the crime of genocide from World War II. So since World War II, there's been a number of responses, including the adoption of the Convention on Prevention and Punishment of Crime of Genocide, 1948. It's quite a mouthful, I know. United Nations leads the international awareness of genocide, which is updated every 2 to 3 years. Now, this is also incorporated into the current and most recent responses to genocide, which the Roman Statute in 1998 was adopted from the Convention on the Prevention and Punishment of Crime of Genocide. So this gave, the Roman Statute gave legislation and legislators a clearer and more defined legal framework that enables not only lawyers but criminal justice systems a framework of elements to determine and legally define the crime of genocide. which I'll go into the issues of the Roman Statute as well in the next slide. So the prevention frameworks for international use as well. This is from the United Nations, and this is the most current response in 2014. This response is for not only international use but also national use, which allows governments a complete understanding of the current approaches and prevention strategies that governments can implement into public departments and give people information on how to prevent, and but also see the risk factors that may start an individual or a group to commit a genocidal act. So this is the current response at the moment for the crime of genocide. Next up, the benefits and the problems of these pieces of legislation. Now, the benefits of these have been tremendous. The United Nations Convention addressed the first humanitarian issue with 149 parties attached to the treaty. This is a huge step forward for modern frameworks and getting the world together to fight human rights and the treatment of humans in other countries. The adoption of international statute has allowed international courts jurisprudence in the area of criminal statutory interpretation. Now, what I mean by this is courts and judges, especially international judges, because there's such a big issue with cross-jurisdictional interpretation of crimes and national and state crimes principles and their legal principles, that the jurisprudence of judges on international courts is such a big factor that allows those judges to look at a variety of laws that can help establish a much clearer understanding of these crimes being committed on an international scale, which trying to interpret not only national laws but international laws as well is such a big task for judges, which is the idea of courts that allows them the jurisprudence and freedom to freely interpret these laws, enables them a better understanding of these legal principles in a whole. So the problems. Now, genocide since 1948 has been strictly defined, and the problem with this is that it has not been allowed to adapt to modern frameworks. Everything that happens in criminal justice systems is ever adaptive. It's constantly changing. Laws are constantly being changed and amended, but the idea of the frozen notion is that these policies that were incorporated in 1948 have not changed since 1948, and it basically limits the ability of courts and judges to interpret these principles from a modern perspective. So this was all from Nuremberg, which was to focus on retribution. So Nuremberg was quite a huge response to the genocide from Nazi Germany, and this retribution led a less legal focus on the trials in Nuremberg. So yes, the legal principles in genocide may lack certain principles as well. So state involvement also is another huge issue that is lacking in the principles. So the elements that are required to determine the crime of genocide, state involvement is not in those elements, and it's very argumentative, but state involvement should be in those elements, as most genocidal acts occur from a political agenda, which has been known throughout time, and this is quite a problem with these policies. And a quick one, lack of criminological research as well is another issue, which is since 1940s there has been little to no research on the actual crime of genocide. I'll quickly get through this. I'm running out of time. Viable directions: international legislative reform, updating and applying current case studies of genocide into legal principles of genocide. Increased collaboration between criminological recommendations and policymakers. Criminological responses would be criminologists will benefit with more intensive research on the events of World War II, in particular defining the crimes committed. So there's been a lot of historical research, but not a lot of criminological research in the area. So these are my future viable directions. These are all research-based and would be valid and an ideal way of combating, defining the crime. So self-reflection, I learned a lot from this course, especially international jurisdictions and how they operate and how they manage to identify crimes from not only a national but an international perspective. There's a lot of tension between national and international courts as well, as the principle of legality comes into play quite a bit, and they sort of have to limit and exclude that principle, which is quite amazing for national legal legislatives, because it's basically excluding their work. So yes, I learned a lot. This is one of my favourite subjects, and thank you for listening to my presentation. This is just my references that I used, the main ones, and hope you enjoyed it.